Compliance with the Worker Adjustment and Retraining Notification Act, or WARN Act, is critical when mergers and acquisitions in the energy sector result in workforce reductions. Both buyers and sellers can face significant liabilities, so these issues need to be addressed early in the deal process. The WARN Act generally requires employers with 100 or more full-time employees to provide at least 60 days advance written notice of a plant closing or mass layoff. In the energy sector, WARN can be triggered by a plant closing affecting 50 or more employees, or a mass layoff impacting either one-third of the workforce or 500 or more employees at a single site. Determining what qualifies as a single site can be particularly complex for energy companies with mobile or remote workers, such as drilling or rig crews, and often requires a case-by-case analysis. Required notice must be provided to affected employees, any applicable unions, and state and local government officials. The notice must include whether the layoffs are permanent or temporary, the expected dates, affected job classifications, and contact information. While there are limited exceptions, such as unforeseen business circumstances, faltering companies, or natural disasters, failure to comply can result in back pay, civil penalties, and attorney's fees. M&A transactions add another layer of complexity. In asset deals, sellers are typically responsible for WARN compliance before closing, while buyers assume responsibility post-closing. In equity deals, WARN liabilities generally carry over to the new ownership. Layoffs occurring before and after closing may also be aggregated, potentially triggering WARN thresholds. To mitigate risk, parties should clearly allocate WARN Act responsibilities in the purchase agreement, require disclosure of recent terminations, include representations and warranties regarding compliance, and provide indemnification for undisclosed violations. Thorough due diligence is essential, including reviewing prior workforce reductions, WARN notices, compliance with state mini-WARN laws, and employee policies. Addressing WARN Act obligations proactively helps ensure compliance, reduce liability, and support smoother transitions in energy sector mergers and acquisitions.